Good afternoon. This video deals with a review of the formative assessment that was done on this past Wednesday. It deals with reus and mens rea. The first part of the problem deals with Ross and actions that Ross has taken, and the question is whether Ross can be charged with negligent injuring for hitting a pedestrian while he was sleepwalking. Last night, Ross was driving his car, ran a red light, and hit a pedestrian who was in a crosswalk. Ross has a peculiar problem. If he drinks before going to bed, he often sleepwalks. He has had this problem for some years. It's very important. On the evening of the accident, Ross and some friends were celebrating his grade of A in criminal law, and he had several drinks. Again, had the drinks is important. He drove home without incident. He had some more to drink, and then went to bed. Later, he walked in his sleep, went out to his car, got in, and drove down the street where the car struck the pedestrian. Ross does not remember anything about the accident. That is very important because it deals with mens rea. Now let's go through and see how they answer the problem. The first thing that I want you to do, because if you look at the problem, the first thing that should trigger here is that Ross was sleepwalking actually when he got in his car and he went and he drove the car, and when he struck the pedestrian. Ross said he remembers nothing about the accident. And so Ross is going to claim that there was not a voluntary act. That's going to be his defense here. Uh, and it's not really a defense because this is a part of the state's case. The state has to prove, as we know, each element of a crime beyond a reasonable doubt. And one element of the crime is the conduct that's necessary that brought about the criminal consequences. And here, the question is whether that conduct that brought about the criminal consequences was an overt voluntary act. First, I'd like for you to, and always for Jones, always give the law. You can start off and you can state the issue here is whether there was a voluntary act. But then after you say that, you must state the law and you must state the law clearly. What is the law in reference to an overt voluntary act? Tell me what a voluntary act is. Tell me there's a will movement of the muscle that person cautiously, a person purposely engaged in the act, or consciously, should not say purposely, but consciously engaged in the act by will movement of the muscle. Then tell me how the Model Penal Code defines a voluntary act. It defines a voluntary act by telling me what a voluntary act is not. Now, you don't have to give me all of the categories that are defined in the Model Penal Code. Just give me the one that applies to this particular hypothetical situation, and that is sleepwalking. That is, the Model Penal Code says that when a person is sleepwalking, an act is committed while a person is sleepwalking, it is not a will movement of the muscle and therefore is not an overt voluntary act. However, we also have a principle that says that every act need not be a voluntary act, but that the criminal consequence must be based upon some voluntary act. And here, we know that if the person sleepwalks and he engages in it, but there's something that he voluntarily engages in that causes him to sleepwalk, and he's aware of the fact that if he engages in this activity and causes him to sleepwalk, that he will not be able to claim that he did not, that his conduct was not voluntary. I'm sorry. So we look back at the problem, and so you write the law. Write a solid statement of the law for Jones. And then after you write a solid statement of the law for Jones, and what happens when you write a solid statement is that it gives you something, a foundation from which you can work. That is, that you have all the principles that are necessary to be proven, are necessary to be discussed in order to answer the question, in order to deal with the question. That is, whether there is a overt voluntary act. And so the first thing that you look at in order to determine whether there's an overt voluntary act is that he was sleepwalking. Now, the second thing that you're going to look at, and it says that he was sleepwalking, but however, if he knew that something that he would do would cause the sleepwalking and he engaged in an act, then this court is going to find that the voluntary act there is engaging in that thing that will result in what is considered not to be a voluntary act. And here he had a problem for some years, and so he was aware of the fact. He was aware that if he drank, that drinking uh, would cause him to sleepwalk. And not only did he drink before he got home, he drank before he got home, and then he drank when he got home. And so he drank excessively. And so he was aware that doing this, that there was a great possibility that he would sleepwalk. And thus, that's the voluntary act. And therefore, the prosecution can prove that there was a voluntary act beyond a reasonable doubt. Now, one of the things that I said that was very important here, well, you have to mention the fact when you talk about the voluntary act that he had the problem for some years. The fact that it's reasonable to assume, it's reasonable to believe, don't assume for me, reasonable to believe that he knew because he'd had it for some years uh, that drinking would cause him to sleepwalk. Now, one other thing that I said that was very important was the fact that Ross said he did not remember anything about the accident. That actually deals with the mens rea. If you go back to the case of Overton, and Overton tied the mens rea and the actus reus together. If you look at our cases, they say that even with a failure to act, there must be some voluntary act. There must be some voluntary act, overt voluntary act, even when there is a negligent act, I should say, not a failure to act, I apologize. Even when there's a negligent act, there must be some voluntary act. We know the negligent act is a standard below, an act that's below a standard of care of a reasonable person, a gross deviation below standard of care of a reasonable person. Here, the question is whether he had knowledge of him being of if the drinking would cause him to sleepwalk. If you go back again, go back to Overton. Overton said that because the state could not show that he knew that the drinking or knew that he was that he had went into the bedroom of a young child and he could not have knowingly committed the act. And so that's what Mr. Ross is going to argue here, that I could not have engaged in a negligent act. I could not have engaged in a negligent act because I did not know the consequences that would have resulted from my uh, from from my sleepwalking, because I actually did not have the mens rea that was necessary. That is, I did not knowingly engage in it. However, he did knowingly engage in drinking. And once he knowingly engaged in drinking, again, knowing that this is going to result in their conduct, then he does have the mens rea that's necessary. Let me see if I can explain that again. What he's going to argue is that I don't even have the necessary mens rea, that I don't have the criminal negligence. I don't have the criminal negligence because I did not act grossly beyond the standard of care of a reasonable person. The reason I didn't act grossly beyond because I did not have knowledge that the act even occurred. I remember nothing about the act. I know nothing about the act. And so I could not act grossly beyond the standard of care. However, he initiated the particular act. Therefore, he knowingly engaged in it. Even though negligent homicide does not say knowingly, but there has to be some mens rea, and the mens rea here is the grossly. And so a reasonable person would not have drank. A reasonable person would not have drank and then went to bed knowing that he sleepwalk. And thus, he does meet the requirement of negligent injury. So let's move on. The next part of it deals with Peel. Peel was a passerby on a motorcycle who saw the entire thing as it happened. Peel, after he saw it happen, he jumped from his motorcycle uh, and he went and he saw that the pedestrian was unconscious and he could not detect a pulse from the pedestrian. And so what he decided to do, he called a friend who was a doctor. The friend told him immediately, do CPR and call for immediate assistance. Peel performed CPR until the pedestrian began to breathe faint and short breaths. Two other drivers had also stopped and watched for a short distance away as Peel performed CPR. Once they saw that the pedestrian had been revived, they left, elated by his temporary success. That is, that I got him back breathing again. I've got him breathing again. Peel leaped to his feet, placed his motorcycle coat over the pedestrian, and left on the side of the road. He did not call anyone or alert anyone to the danger that the pedestrian was in, or did not give the pedestrian any additional assistance. He left him there on the side of the road. Pedestrian was found dead the very next day uh, by a young lady. Uh, by a young lady. Uh, Peel was arrested, and the question now becomes: can he be charged with the death, negligent homicide of of the uh, of the pedestrian? I'm sorry. Now we know what the question is there. The question is a failure to act. He failed to act. Well, how did he fail to act? He failed to act because he didn't complete the action that he started. Now let's go back and let's take a look at it. Again, what does Jones want you to do? You can start off and say, here the question is a failure to act, or here Peel will be found guilty of negligent homicide because of his omission of failure to act. But what you have to do, the first thing you got to do for me is you got to tell Jones the law. Please give Jones a clear statement of the law. Again, the law sets the stage for you. It sets the stage and it helps your analysis a lot. Once you give the law, you give the correct law, you give a concise, thorough statement of the law, then again you use that law for the purposes of, of, of your answer, for the purposes of putting your answer together. It is the outline for your answer, the law is, and the outline of how you use the facts in the answer. And so you start off, you tell me, you explain that a person is guilty for his failure to act when a person has a legal duty. Uh, and a legal duty here is generally found when a person, in one of several reasons. In Louisiana, we do not recognize, Louisiana courts have not recognized these, but if you look at them, they do define what a reasonable person would do under certain circumstances and certain conditions. And if we look at these reasons that have been determined to be legal duties by common law, and these reasons, and one of these reasons is the voluntary assumption of care. You don't have to list it. You don't have to list all of the others. You don't have to list the other five that I say that we may use on a hypothetical, on a question on my exam. You only list that one which is important. You only list that one which you're going to use. You only list that one which the facts say, this is it. This is what the problem is about. And here, the question is whether there was a legal duty based upon his voluntary assumption of care. Now he did. He assumed the care of the person. He assumed the care of the person. And once he assumed the care of the person, what was his duty? And then you go back and you talk about what the duty was. You talk about that first he had to be aware of it. He has to be capable of performing the act. He has to be capable of performing the act without endangering himself. Jones needs to hear all of that. And here he was capable of performing an act that would have necessarily prevented the person from dying. You got to put in this question and answer the autopsy report. The autopsy said that if he had gotten immediate attention, that is attention, not even immediate, attention within 3 hours of being struck, that he would have lived. And there was no question about it. It was uncategorically stated that he would have lived if he'd gotten attention within 3 hours. And so Peel going there and Peel actually stopping and giving aid and then pulling off even though he had information from a trained doctor that he needed to call medical assistance immediately. He jumped up, he went off to celebrate what he had done. Thus, he did have a duty to act based on a voluntary assumption of care, and its ability to complete that assumption of care by just merely calling assistance. And that's all he had to do, was to call assistance. And another thing that is important here, when you voluntarily assume care, you want to look at did he do it to the detriment of others who may have been around? And so that's why the pedestrians are here, because the pedestrians, the other car was here, the other two cars, because the other two cars, the person in the other two cars may have given assistance if they believed that he had not gained control of the situation. And here it appears that he gained control of the situation, and so they left. And thus he prevented also others from coming to the aid. And so you can also say that Because of what he did, he prevented others who were on the scene from coming to the aid, and therefore he does have an obligation once he has assumed the care of this particular person. Now, that second part is not really necessary. It's not really necessary because once he had assumed he got the information to call someone and he left the man on the road to die, that was enough. But you have additional facts there. If Jones places the facts there, it's important. Going back to the first part of it, when he said he didn't remember, Jones placed that fact there for a reason. That fact was for the purposes of you talking about the mens rea. The fact that they pedestrians were there and they left, it was for the purposes of talking about whether he excluded them or precluded them from coming to assistance because they believed that he had control of the situation. Now, one thing that I did not want you to do with the other two cars that were there, other car that was there, and saw Peel engaged in the acts, I did not want you to deal with them as far as whether they would have been charged because they left. That was not a part of the problem. That was not the question. What you do with Jones, you read the question and you deal with the question. Don't add anything, do not subtract anything. And for the most part, that is it. That's it. Very simple, very straightforward. I've looked at a couple of the papers and they're not too good. We'll go over it again and I'll call some of you all in who did not do very well for the purpose of sitting with you and giving you some instructions on how to answer the exam. With that, I've been here 16 minutes and 29 seconds and we're going to end this video. Thank you very much. Goodbye.